Thank you, Mr. Speaker. Members, in a public hearing on Wednesday, May 24th, the House General Investigating Committee heard approximately 3 hours of detailed, compelling testimony from a team of highly trained and experienced investigators, including multiple attorneys who have served as prosecutors specializing in white-collar crime and public integrity cases. The testimony reported facts relating to and supporting claims of multiple instances of misconduct committed by Attorney General Kim Paxton. You have been provided a transcript of that hearing and have had an opportunity to view and consider the video broadcast of the entire public hearing. Members, it is important to provide you with a concise summary of the pertinent facts brought forth in that hearing. In doing so, I intend to focus on what I believe is the primarily relevant, the matters demonstrating that Attorney General Paxton abused his office and his powers for personal gain. I will address several issues reported to our committee. First, let's visit about Nate Paul. Nate Paul is a real estate investor in Austin. Nate Paul was also a friend of Attorney General Paxton and a donor to Attorney General Paxton. Nate Paul had a real estate business, World Class Holdings. Nate Paul was in trouble with federal law enforcement. In August of 2019, FBI agents executed search warrants at Nate Paul's home and his business, World Class Holdings. Nate Paul owned and controlled World Class Holdings, and World Class Holdings controlled a number of other entities. In November of 2019, attorneys for Nate Paul made Public Information Act requests to the Texas State Securities Board for documents relating to the search warrants issued against Nate Paul and his businesses. The State Securities Board requested an Attorney General's opinion as to whether or not it was required to release the records. The Attorney General's office issues approximately 30 to 40,000 open records decisions each year. There is no evidence that Attorney General Paxton had ever taken a personal interest in any of those decisions except for this one that related to Nate Paul. Although the requested information clearly fell within the law enforcement exception and would not have to be released, Attorney General Paxton pressured the OAG staff to issue an opinion that would have allowed for the records that Nate Paul sought to be released to Paul. A highly unusual move that was contrary to well-established precedent relating to protecting the integrity of criminal investigations. Despite pressure, the OAG issued a ruling that all records relating to the request were not subject to disclosure due to a pending criminal investigation of Nate Paul. In March of 2020, Nate Paul's lawyers tried again, this time making a Public Information Act request to the Texas Department of Public Safety for documents relating to the search warrants issued against Nate Paul and his businesses. DPS, you see, had cooperated with and assisted the FBI in the execution of the search warrants against Nate Paul. Because the search of Nate Paul's home and businesses was conducted by the FBI filed a brief with the OAG urging the OAG to follow its longstanding practice, policy, and procedure of not providing documents relative to an ongoing criminal investigation. A redacted version of that brief was sent to Nate Paul's attorneys, but Nate Paul wanted the unredacted version. And Attorney General Paxton tried to help him get it. DPS requested an Attorney General's opinion as to whether or not it was required to release the records. Again, Attorney General Paxton pressured a Deputy Attorney General to issue an opinion that would have allowed for the records that Nate Paul sought to be released to Paul, including the unredacted FBI brief. Attorney General Paxton revealed that he had spoken personally with Nate Paul and told OAG staff that he didn't want to help the FBI or DPS in any way. Attorney General Paxton then took the entire file that had all of the responsive documents, including documents sealed by a federal court, and didn't return them for approximately 10 days. Attorney General Paxton then directed that the final opinion be issued and that the OAG take no position on whether the documents should be released. Then, in May of 2020, Nate Paul's lawyers made another Public Information Act request, this time to the OAG, seeking the unredacted FBI brief. Attorney General Paxton directed the same Deputy Attorney General to find a way to release it to Nate Paul and to draft an opinion authorizing the release. Attorney General Paxton then directed an aide to deliver a manila folder directly to Nate Paul at Nate Paul's place of business. The contents of the folder were never disclosed to OAG staff, and Nate Paul never followed up to attempt to compel production of the requested documents. Presumably, there was no need to. Next, let's talk about the Mitty Foundation. The Roy F. and Joanne Cole Mitty Foundation is a nonprofit corporation and charitable foundation located in Austin. Aside from performing a number of charitable purposes, it invested in and was a limited partner of several entities controlled by World Class Holdings, again, Nate Paul's company. The Mitty Foundation filed suit against several of those entities controlled by Nate Paul's World Class Holdings, claiming, among other things, that the Mitty Foundation was being denied access to the books and records of the companies, a right generally that every limited partner has. The litigation grew and later resulted in a court-appointed receiver being appointed over the entities. Now, the Financial Litigation and Charitable Trust Division of the OAG is entitled to receive notice of any litigation involving a charitable organization in the state of Texas. The OAG can intervene in such cases if the determination is made by the OAG that it's necessary in order to protect the assets of the charity. In January of 2020, after receiving notice of the pending litigation, OAG lawyers in the Charitable Trust Division filed a notice with the court declining to intervene in the case, a standard practice and reasonable under the circumstances since the Mitty Foundation was well represented by very capable counsel. However, in May or June of 2020, Attorney General Paxton began to take a deep personal interest in the case. The OAG has approximately 35,000 open civil cases each year, but this is the only one that Attorney General Paxton had ever taken a personal interest, the one involving Nate Paul. Attorney General Paxton had several discussions with the OAG staff about intervening in the case. Against the advice of the OAG staff and contrary to the OAG's prior determination not to intervene, Attorney General Paxton directed the Charitable Trust Division to intervene in the lawsuit. After intervening, Attorney General Paxton instructed a Deputy Attorney General to review the pleadings in the case. That Deputy Attorney General informed Attorney General Paxton that the OAG had no interest in the case, the OAG shouldn't waste its resources on the case, and that the parties in the case had already reached a $10.5 million settlement agreement, which Nate Paul subsequently breached. In other words, he defaulted on his obligation to pay the $10.5 million. The Deputy Attorney General strongly advised Attorney General Paxton to have nothing to do with Nate Paul and to get out of the case. So intense was Attorney General Paxton's desire to help Nate Paul in the case that he even suggested personally attending and appearing before the court, which would have been unprecedented. Attorney General Paxton directed OAG staff to file a motion to stay the case, in other words, stop the case, to force a mediation, a move which hurt the Mitty Foundation's position in the case and only helped Nate Paul's position, a position contrary to the best interest of the Mitty Foundation, to which the OAG's office had a fiduciary obligation due to its representation. Based on Attorney General Paxton's directives, the OAG attempted to force the Mitty Foundation to settle the case for about $5 million, less than half of the $10.5 million for which they had previously agreed to settle. The OAG subsequently withdrew from representation. The case moved forward and the Mitty Foundation recovered a judgment for $21 million from a forced sale of some of Nate Paul's properties. Meanwhile, Nate Paul continued to have financial problems. 13 properties belonging to Nate Paul's business entities and to which Nate Paul was a personal guarantor were scheduled to be foreclosed upon on Tuesday, August 4th, 2020. Approximately 4 days before that, on Friday, July 31st, 2020, Attorney General Paxton contacted OAG staff to look into whether restrictions on in-person gatherings due to COVID could prevent foreclosure sales of properties. Attorney General Paxton then made it clear that he wanted the OAG to issue an opinion by Sunday prior to the sale, stating that foreclosure sales could not be permitted to continue. That was contrary to established law, policies, and procedures, and that there was no written request for such an opinion from a qualified requester, and the time frame for responding to a request like that is typically about 180 days due to research, preparation, analysis, and review. When asked who requested the opinion, Attorney General Paxton gave no name, produced no letter requesting the opinion, and only gave staff a phone number, which was incorrect. Attorney General Paxton was wanting the opinion letter done in 2 days, over the weekend. The opinion letter was prepared and issued, but was never published, as are other opinion letters. The effect of that opinion letter was used to thwart the foreclosures of Nate Paul's properties. In May of 2020, Attorney General Paxton contacted the Travis County District Attorney and requested a meeting to help Nate Paul present a criminal complaint against federal and state law enforcement officials, prosecutors, and judges. The complaint was presented, but Nate Paul refused to swear to the truth of the allegations contained in the complaint. As expected, the Travis County District Attorney refused to have anything to do with an unsworn complaint and referred it to the OAG. Staff at the OAG investigated the claims and determined that no credible evidence existed to support any criminal charges. Attorney General Paxton, however, disagreed and insisted that a criminal investigation move forward. In August of 2020, Attorney General Paxton sought OAG staff assistance in seeking outside counsel. That would have been a violation of OAG policies and procedures, in that the OAG seldom seeks outside counsel on criminal cases, due in large part to the fact that they've got approximately 800 assistant attorneys general on staff to handle criminal matters. But Attorney General Paxton was informed that the OAG's approval process for handling outside counsel requires authorization from at least 10 different OAG personnel throughout several stages, all designed, at least in part, to prevent the hiring of unqualified, conflicted lawyers. Further, the process is designed to be able to draft and approve a contract to make assessments, approvals for funding, and things of that nature. However, again, hiring outside counsel for a criminal case is seldom necessary. Attorney General Paxton later fought assistance on the ability to retain outside counsel to investigate criminal allegations. Attorney General Paxton was advised that Texas law only allows that in a couple of circumstances. One, if a prosecutor recuses himself or herself and the trial court appoints an attorney pro tem as a prosecuting attorney, or two, if a prosecuting attorney requests the assistance of the Attorney General and the Attorney General offers the prosecuting attorney the assistance of his office. Attorney General Paxton later informed OAG staff of his decision to retain Brandon Kamek, a criminal defense attorney who had been licensed only 5 years and had never served as a prosecutor. It was later disclosed that the source of the referral, where did Kamek come from, was, of course, Nate Paul. Attorney General Paxton instructed OAG staff to draft an outside counsel contract and send it to Kamek immediately. Kamek approved the contract but didn't date it and began acting under the guise that he was approved by the OAG, although the contract had not yet been approved. OAG staff refused to approve the highly irregular contract. Attorney General Paxton continued to be involved, meeting with and pressuring staff to approve the contract. OAG staff continued to refuse to approve the contract and notified Attorney General Paxton that the contract was not yet approved. Despite this non-approval of the contract to retain Kamek, Attorney General Paxton instructed Kamek to begin work. The contract was never approved. The contract, even if it would have been approved, did not identify Kamek as a prosecutor. It specifically stated that Kamek was not to provide indictment or prosecution legal services. Despite this, at the instruction of Attorney General Paxton, Kamek proceeded to conduct work and falsely represent himself as a special prosecutor in order to obtain 39 grand jury subpoenas directed to Nate Paul's adversaries relative to the Nate Paul complaint, which were directed to the very law enforcement agencies and entities contained and specific documents referred to in the FBI unredacted brief that Nate Paul was never to have received a copy or access. The parties and information contained in the subpoenas would not have been knowable unless someone had access to the unredacted FBI brief. The subpoenas were signed by Kamek as special prosecutor. Further, Nate Paul's lawyers accompanied Kamek when serving one or more of the OAG subpoenas. All of these actions were taken under the instruction, involvement, and approval of Attorney General Paxton. When the OAG staff learned of the issuance and service of the subpoenas, they had them quashed or canceled. In summary, what I've outlined to you is not an exhaustive list of the claims and issues presented to our committee. It is, however, a compelling substantiation of the fact that Attorney General Paxton abused his office and his powers for personal gain. Attorney General Paxton continuously and blatantly violated laws, rules, policies, and procedures, improperly and illegally using OAG staff, resources, and monies to intervene and interfere in the civil disputes and criminal matters of his donor and friend, Nate Paul, and benefiting himself. Members, I remind you that your function in this process is to act somewhat in the capacity of a grand jury. An impeachment is similar to a criminal indictment and must be followed by a trial in the Senate. You don't have to have proof of anything beyond a reasonable doubt or by a preponderance of the evidence. The House decides only if there is sufficient evidence to justify further legal proceedings. Today is a very grim and difficult day for this House and for the state of Texas. Attorney General Paxton has a brilliant legal mind and has worked diligently for the state of Texas. I have great appreciation and respect for the many, many things that he has done for this state. Frankly, Attorney General Paxton deserves praise for his fierce, consistent efforts to push back on behalf of Texas against unconstitutional federal mandates, executive orders, rules, and laws. But members, no one person should be above the law, least not the top law enforcement official of the state of Texas. We each took an oath of office. Attorney General Paxton took an oath of office. He violated that oath. He put the interest of himself above the laws of the state of Texas. He put the interest of himself over the established laws, policies, and procedures of the Office of the Attorney General. He put the interest of himself over his staff, who tried to advise him on multiple occasions that he was about to violate the law. He put the interest of himself over the top officials in the Office of the Attorney General that he fired and retaliated against for reporting in good faith their belief that he violated the law. He put the interest of himself over the lawful functions of the FBI, the DPS, and other law enforcement agencies and prosecutors in their attempts to investigate and prosecute criminal activity. He put the interest of himself over the taxpayers, whom he asked to foot the bill for millions of dollars to pay for his illegal activity and to pay for his personal interest, all without having to answer any questions under oath about his activities and actions. And he put the interest of himself over the citizens of the state of Texas. Members, it brings me no pleasure to be standing here today in front of you dealing with this matter. I know that it's not pleasant for you either. But we have a duty and an obligation to protect the citizens of Texas from elected officials that abuse their office and their power for personal gain. As a body, we should not be complicit in allowing that behavior. We should not ignore it and pretend it didn't happen. Texas is better than that. Thank you, members.